Hello friends, welcome back to my channel. I am CS Jaspreet. Today we will do the company law amendments of part B only. And today in this video we will only do the amendments of part B because as we consider part B is very important part of company law. So we will only do the amendments of part B that relate from chapter 16 to chapter 20. So only the part B amendments will be dealt today in this video. Starting with the first chapter which is directors, and you will be happy to know कि इसमें amendments के साथ साथ उन्होंने question answers भी दे रखे हैं which can be asked in exam. Direct उन्होंने question answers बना के दिए हैं जो directly exam में पूछे जा सकते हैं आपसे. So as you proceed further you will see कि किस तरीके से question answers उन्होंने पूछे हैं और उसी तरीके से same way में या थोड़ा बहुत change करके case study की तरह पूछे जा सकते हैं. First amendment in the rule is after the words for inclusion the words or renewal shall be inserted. तो जहां पे for inclusion लिखा है उसके साथ ही words insert हो जाएंगे और renewal. And further in the sub rule a new sub rule is inserted which says in case of delay on the part of an individual in applying to the institute for inclusion of his name in the database, or in case of delay of filing an application for renewal, the institute shall allow the inclusion or renewal as the case may be after charging a further fee of 1000 rupees for such delay. तो इसका brief analysis करें तो ये इसका अमेंडमेंट का इफेक्ट आता है that it provides that in case of delay on the part of an individual in applying to the IICA as you know जो डाटा बैंक पूरा मेंटेन करते हैं for the independent directors for inclusion of the name or in case of delay for renewal. So basically this 1000 rupees, this further fees of 1000 rupees is both on application of inclusion of the name or for renewal of the same, because once you do it for a while, for example सिर्फ एक लाइफ टाइम में रिन्यूअल की जरूरत नहीं होती, बाकी सब में रिन्यूअल की जरूरत होती है. So when you do for a prescribed time and you fail to renew it, there's a delay in renewing it, or for the inclusion of name in the data bank, in both the cases it can be done by IICA through the application with a further fee of rupees 1000 rupees. So basically दोनों में ही fees same है for inclusion of name also and for delay in renewal also. The second amendment tells us about that what MCA has amended in companies appointment and qualification of directors rules. So firstly the following clause has been substituted, namely in the pay scale of director or equivalent or above in any ministry or department of the central government or any state government and having experience in handling the matters relating to commerce, corporate affairs, finance, industry or public enterprises, or the affairs related to government companies or statutory corporations set up under an act of parliament or carrying on commercial activities. So this is the first clause of amendment, and in the second amendment they tell us about the following individuals who have been for at least 10 years advocate of a court, practice in chartered accountant, practice as a cost accountant, practice as a company secretary. They also need not pass the online proficiency self-assessment test. And what is the brief analysis? The amendment provides that an individual is exempted to pass the online proficiency test to be included, because this test you have to give if you want to be included in the independent directors data bank. ये test देना और pass करना बहुत जरूरी है. But if a person has served for a total period of not less than 3 years as on the date of inclusion in the pay scale of a director or equivalent or above any ministry or department or the central government or any state government having experience in the matter of commerce, corporate affairs, finance, industry, and so basically if these people they have served for not less than 3 years on the date of inclusion, they need not give the test. They are exempted from the text or test and they can directly apply for the independent director without any test. तो ये जो लोग हैं अगर उन्होंने 3 साल तक इस पोजीशन पे सर्व किया है, स्पेस स्केल पे सर्व किया है, सो ऑटोमेटिकली उन्हें टेस्ट देने की जरूरत नहीं है. वहीं पे ये जो प्रोफेशनल्स हैं जो 10 साल से प्रैक्टिस में है, इन्हें भी ऑनलाइन प्रोफिशिएंसी टेस्ट देने की जरूरत नहीं है. मूविंग फर्दर टू द कंपनीज क्रिएशन एंड मेंटेनेंस ऑफ डाटा बैंक, सो दे से दे हैव फर्दर अमेंडेड एंड फॉलोइंग न्यू रूल हैज बीन इंसर्टेड रिगार्डिंग द एनुअल रिपोर्ट ऑन द कैपेसिटी बिल्डिंग ऑफ इंडिपेंडेंट डायरेक्टर्स. द इंस्टीट्यूट शैल विद इन 60 days from from the end of every financial year, 60 days from the end of every financial year, send an annual report to every individual whose name is included in the data bank, and also to every company in which such individual is appointed as an independent director in format provided. So basically, it is about the format of annual report on capacity building of independent directors. They say that IICA, which is Indian Institute of Corporate Affairs, they shall within 60 days from the end of every financial year, they have to send an annual report of every individual whose name is included in the data bank, and also to every company in which such individual is appointed. So it is just like an annual report of that individual. Annual report भेजनी है उन्होंने, हर एक इंडिविजुअल को भेजनी है वो एनुअल रिपोर्ट, और हर उस कंपनी को भेजनी है ये एनुअल रिपोर्ट जहां पे वो जो इंडिविजुअल है वो जहां पे अपॉइंटेड है. सो बेसिकली दे से द इंस्टीट्यूट विच इज IICA, the institute which is Indian Institute of Corporate Affairs, they have to send within 60 days the annual report. उन्हें annual report भेजनी है. किस किस को भेजनी है? They have to send the annual report to the individual, and they have to send the annual report to the company in which that individual is appointed as an independent director. तो ये institute की duty है ये annual return भेजने की. Then comes certain questions. तो ये questions अगर आपने study material ध्यान से पढ़ा होगा तो एक box वहां पे mentioned है when we study the independent directors, उसमें भी ये questions दे रखे हैं, but उनके लिए जिन्होंने questions कभी नहीं देखे उनके लिए बहुत beneficial है because इसमें से questions पूछे जा सकते हैं in exam. Starting with the first, whether the spouse as in husband or wife of secretarial auditor or statutory auditors of the company be appointed as an independent director. So starting with the point of independent डायरेक्टर, as we all know, independent director means जो बिल्कुल independent है. He has no pecuniary or material interest in the company. Talking about a spouse, so an independent director in relation to a company is a person who neither himself or nor his relative nor his employee should be associated for 3 financial years preceding the financial year in which he is proposed to be appointed of a firm of auditors or company secretaries in practice or cost auditors of the company or its holding subsidiary or associate. Hence, such a person whose spouse is the secretarial auditor cannot be, because now he is related to the auditor, and this is given under section 149 6E2. So that person cannot be appointed as an independent director. So the answer to this is no. You can mention here like this, right? Next, can a friend of a director be considered as independent? Yes. So basically, law does not prohibit the appointment of a friend because he's not a relative, right? So friend is eligible if he fulfills all the legal requirements. Can a spouse of an independent director be appointed as an independent director? No. No, a spouse cannot be appointed, which provides that an independent director in relation to a company means one who is related to promoters or directors its holdings. So no, that person cannot be appointed. Can an independent director be appointed for the first term as an additional director by the board of a company? So they say that independent directors shall be approved in the general meeting, as we know, and 152 mandates save as otherwise every director shall be appointed in the general meeting. 161 confers that on the board of a company power to appoint any person other than a person who fails to be appointed in the general meeting. So as you know, additional director is actually appointed by the board, and he holds the office up to the conclusion of next AGM or when it is ought to be held, whichever is earlier, right? ये तो normal scenario है additional directors का. तो ये सारी चीजें जब हम एक साथ पढ़ते हैं, it means that power on the board to appoint additional directors designated as independent directors subject to approval of shareholders. Because देखो, जो additional director हैं वो board appoint कर सकते हैं, और जो independent directors हैं वो general meeting में shareholders appoint कर सकते हैं. These are the two scenarios you need to know before concluding the case study. First thing, that independent directors can be appointed by the general meeting by the shareholders, and additional directors to be appointed by the board. So now they say that appointment of independent directors shall be approved at the meeting. So what is the nutshell that they are saying? They do not imply that there is a prior approval of shareholders for appointment of an independent director. Therefore, it can be said that independent director can be appointed by board as an additional director and his appointment can be approved by the shareholders at the next AGM. So इस तरीके से आप जो है हम इसे conclude करते हैं that yes, independent director can be appointed as an additional director provided that it will be subject टू अप्रूवल इन द जनरल मीटिंग. तो दोनों चीजें हो गई, दोनों चीजें सेटिस्फाई हो गई. बोर्ड ने अपॉइंट कर दिया और जनरल मीटिंग ने उसकी जो अपॉइंटमेंट है उसे अप्रूव कर दिया. सो दिस इज हाउ वी नीड टू चेक. Next is, can an independent director be appointed as an additional director by board for a second term? So once is now the earlier question was for first term and this is for second term. Talking about the second term, an independent director shall hold office for 5 years if he is eligible for reappointment and he cannot be appointed for more than 2 years. तो ये सारी चीजें तो आपको पता है जो जनरल चीजें डिसाइड होती हैं. And the term consecutive means back to back. I hope you know that independent directors can be reappointed for 2 consecutive years and then a cooling period of 3 years is given to that. So ये सारी चीजें हो गई. So while going through the definitions, it becomes clear that an independent director is eligible to be reappointed for a second term, definitely, and that too by special resolution. Therefore, obtaining shareholders consent prior to his reappointment in considered view is a prerequisite to be eligible for a second term, because now we say he has to be approved through a special resolution. So we can say that yes, a prior approval is needed. So if the shareholders approval for the second term is not taken as on the last date of first term, then such independent director cannot be reappointed as an additional director for second term, as he does not possess the eligibility to get reappointed. Hence, he ceases to be a director at his first term. So basically, you will have to take the appointment on the last term, otherwise he will cease to be a director. Because unlike in the above question, first term में क्या था कि उसे prior approval की जरूरत नहीं है, तो वो कहते ठीक है बोर्ड रख ले और जो जनरल मीटिंग में शेयर होल्डर्स हैं वो से अप्रूव कर ले, बात खत्म हो गई. लेकिन सेकंड टर्म में क्योंकि हमें स्पेशल रेजोल्यूशन चाहिए, अगर वो लास्ट डे पे अप्रूव कर देते हैं तो ठीक है, अदरवाइज उसका जो टेन्योर है वो खत्म हो जाएगा. सो इन द सेकंड टर्म वी नीड टू कंसिडर दिस फैक्ट दैट बिकॉज वी नीड द प्रायर अप्रूवल ऑफ शेयर होल्डर्स, बिकॉज वी नीड स्पेशल रेजोल्यूशन, we need to check that either it has to be done on the last date of the first term, otherwise his term will be ended. Moving ahead to the next question, they say whether circular resolution is allowed for appointment of an independent director while appointing him for the first term. तो क्या हम circular resolution लगा सकते हैं? They say there is no restriction on appointment of an independent director by way of circular resolution if he is to be appointed by board as an additional director. However, it must be ensured that NRC of the company has duly discussed and recommended the candidate before the circulation. So अगेन अगर वो एडिशनल डायरेक्टर की तरह अपॉइंट होना चाहता है तो सर्कुलर रेजोल्यूशन में कोई भी रिस्ट्रिक्शन नहीं है, जस्ट फॉर द एनआरसी, बिकॉज एनआरसी डील्स विद अपॉइंटमेंट एंड डिसाइडिंग द टर्म्स ऑफ रेम्युनरेशन. दे हैव टू कंसिडर एंड फाइनलाइज द कैंडिडेट before going into circulation. Then can appointment of independent director be done to fill the casual vacancy which is created by resignation of any other independent director? So what happens whenever any existing independent director ceases to be a director of the company either due to resignation, death or otherwise, then in order to ensure the requisite board composition, a new independent director should be appointed because you need to fill it. वहां पे वो position खाली हो जाती है, उसे भरनी जरूरी है. The board can appoint an individual either as an additional director of the act to hold office till the next annual general meeting of the company, or he can be appointed as a director in the casual vacancy to fill the vacancy created in the office of independent director. So it may be noted that if a director is appointed by the board to fill the casual vacancy, so basically they say कि casual vacancy कौन fill करता है? वैसे board fill करती है casual vacancy, right? तो it may be noted if a director is appointed by the board to fill the casual vacancy, then as we say in 161(4) read with secretarial standard, his appointment should be approved at the board meeting and not through the resolution of circulation. So such appointment should also be approved by members in the immediate next general meeting. and such director shall only hold the office up to which he is appointed on the place of the independent director if he had not been vacated. जो सारी scenarios हम पढ़ते हैं casual vacancy में. So the first term of such newly appointed independent director shall be lesser than 5 years, which he would otherwise got if he had been appointed as additional director. So yes, they can appoint it, just what is again necessary that they need to get it approved in the next general meeting, because जहां पे बात independent director की होती है और board के साथ वो clash हो जाती है. Simple बात है, जहां हम additional director की भी बात की वहां पे भी बोला ठीक है you can do it, but for the first term please take the approval, like after that they should be approved by the shareholder. Here also because casual vacancy board करता है तो वो कर दे, but after that they need to take the approval of the shareholders as well. Then whether the end of first term of director without reappointment of second term or end of second term terminates directorships of a director, they say he shall hold an office up to 5 consecutive years but shall be eligible for reappointment by special resolution based on the recommendation of NRC, and disclosure of such appointment shall be made in the board's report. So since the term used is holding office for a term up to 5 consecutive years, he will cease on the expiry of 5 years. Hence, he will lose or vacate his directorship also on the expiry of first term और सेकेंड टर्म. सो अगर रीअपॉइंटमेंट नहीं होगी तो ऑटोमेटिकली उसकी एक्सपायरी हो जाएगी. जितना टर्म होता है अगर उस टर्म में उसकी रीअपॉइंटमेंट नहीं होती है तो उसका जो फर्स्ट टर्म है वो खत्म हो जाएगा. सेकेंड टर्म में नहीं होती है तो सेकेंड टर्म भी उसका फिनिश हो जाएगा, वेकेट हो जाएगा. If a known person is to be appointed as an independent director, should his name be mentioned in data bank? Of course, any person who intends to be appointed as an independent director, उसका नाम data bank में होना ही चाहिए, because when you study the topic of data bank, it is mainly about that the people who can be approached by the company, to whom the company can approach, basically, right? The company can approach these people and can actually take up the matter that yes, we need to appoint these people, and wherever their scenarios match they can call up that person. Any person whoever is interested to be an independent director, definitely his name has to be in the data bank, and it always is convenient for the company to actually include the name and approach the same person. Moving ahead to the fifth amendment, that is in appointment and qualification of directors, which says that the amendments inter alia provide that in case the person seeking appointment is a national of a country which shares land border with the necessary security clearance with the Ministry of Home Affairs, shall also attach the consent DIR 2, and no application number will be generated in case a person applying for DIN is a national of a country which shares land border with India, unless necessary security clearance from the Ministry of Affairs along with DIR 3 is attached. And thirdly, in DIR 12 also a declaration is inserted to be opted by persons seeking appointment as director as to whether the national of a country which shares the land borders with India has sought necessary security clearance from the Ministry of Home Affairs or not. तो तीनों में एक ही बात आपको देखने मिल रही है कि जो नेशनल है वो एक ऐसे कंट्री से है जो लैंड बॉर्डर शेयर कर रहा है विद इंडिया, दे नीड अ सिक्योरिटी क्लियरेंस फ्रॉम द मिनिस्ट्री ऑफ होम अफेयर्स. एनीबडी हु इज इंटरेस्टेड टू बिकम अ डायरेक्टर and he's a national of a country which shares its land borders with India, they need to take or they need to ask for the security clearance from the Ministry of Home Affairs, right? Brief analysis again, as I've told you, MC has introduced in its various forms. Now in yesterday's video also we have read two forms. One was SH4, second was PAS4, in which we required the declaration that whether you require the government approval or not when you share the land borders with India. In the same way, now actually they had come up with lot many forms. Now they have entered with the security clearance. So here they say if a person is seeking appointment and he is a national of a country which shares land borders with India, they need to take or they need to obtain the necessary necessary security clearance from Ministry of Home Affairs, and they have to attach it with the consent as well. Similarly, no application number. Now in DIN, an application number is generated whenever you ask for a DIN, apply for a DIN, तो एक application number आ जाता है basically later reference के लिए. आज आपने फॉर्म फाइल कर दिया तो वो जब भी आएगा उसे रेफर करने के लिए एक एप्लीकेशन नंबर होता है, वो आ जाता है. वो भी जनरेट नहीं होगा अगर आप DIR3 जो कि डिन की एप्लीकेशन का फॉर्म होता है उसके साथ गवर्नमेंट कॉन्सेंट नहीं लगाते हो, सिक्योरिटी क्लियरेंस नहीं लगाते हो. ऐसे ही DIR12 में आपको इंसर्ट करना पड़ेगा which needs to be opted by person seeking appointment as a director कि उन्होंने सिक्योरिटी क्लियरेंस सीख किया है या नहीं. इट इज गुड क्योंकि इट प्रोवाइड्स लॉट ऑफ I would say safety and security from any kind of wrongdoings. तो उसी के लिए ये सारी चीजें इंसर्ट की गई हैं. तो मेनली DIR2, DIR3 एंड DIR12 तीनों में ही आपको चाहिए एक नेसेसरी सिक्योरिटी क्लियरेंस फ्रॉम द मिनिस्ट्री ऑफ होम अफेयर्स उन पर्संस के लिए हुआ नेशनल्स ऑफ अ कंट्री हु शेयर द लैंड बॉर्डर विद India, right? The next amendment states companies appointment and qualification of directors. Second amendment, they say it has inserted which is specifying any individual whose name has been removed from the data bank may apply for restoration with 1,000 rupees, and IICA shall allow the restoration subject to following conditions. Now, like we told that if there's delay of renewal or for inclusion, you have to pay 1,000 rupees. But on the part of IICA, they shall allow the restoration subject to the following conditions, like his name shall be shown in separate restored category for a period of 1 year. For 1 year, that person's name will be shown in a separate restored category, and he shall be required to pass the online proficiency self-assessment test. Thereafter, his name will be included in the data bank. तो technically क्या होता था कि 1 साल का टाइम पीरियड मिल जाता था नेम इंक्लूड करने के बाद कि आप जो है अपना टेस्ट पास करो. तो उन्होंने बोला 1 साल तक पहले आपको अलग रिस्टोर्ड कैटेगरी में रखा जाएगा. द मोमेंट यू विल पास द टेस्ट, फिर आपको एक्चुअल सारे सबके साथ जो सारे इंडिपेंडेंट डायरेक्टर्स है वहां पे डाल दिया जाएगा. ओनली इफ ही पासेस द टेस्ट, बिकॉज probably his name is there and he has not passed the test, and he can be approached by the companies because company को तो नहीं पता ना. The companies don't know. For that they have made a separate restored category. इनका नाम सेपरेट रखो ताकि उन्हें पता चल जाए कि इन्होंने अभी तक टेस्ट नहीं दिया, और जैसे ही वो टेस्ट दे देंगे उनका नाम इंक्लूड कर लिया जाएगा. Only if they pass the test. The fees paid by him at the time of initial registration shall continue to be valid for the period for which the same was initially paid. वो valid रहेगी, उसमें कोई प्रॉब्लम नहीं. And if he fails the test, टेस्ट नहीं पास कर पाया within 1 year from the date of restoration, the name shall be removed and he shall be required to apply afresh. तो ये ऐसे होता था. बस इन्होंने क्या किया, they have made a separate category. Now his name will be separate and he will have to pass the test within 1 year. The moment he passes the test, his name will be included with all other independent directors, right? And the fees will stay valid. But up till that 1 year, if he is unable to pass the test, उस 1 साल में अगर टेस्ट पास नहीं किया तो the name will be removed and he will have to apply afresh. यानी कि दोबारा फीस भरनी पड़ेगी. इंटरप्रिटेशन उसका ये, दोबारा फीस भरो, दोबारा अप्लाई करो. तो अगर नहीं करना चाहते हो तो 1 साल के अंदर अंदर टेस्ट क्लियर कर जाओ. The next amendment says that which has come into force on the date of publication of the official gazette according to the amendment E form 3 KYC and 3 KYC web. इनमें थोड़ी amendments आई थी, ये forms थोड़े थोड़े change हुए थे, ये उसके बारे में है. Then SEBI amendment regulation 2022 which says the pursuant to ease of resolution requirements for appointment or removal of independent directors. So SEBI has inserted stating that where a special resolution for the appointment of an independent director fails to get the requisite majority, and they fail to get the requisite majority of votes, but the votes cast in favor they exceed the votes cast against, and the votes cast by public shareholders in favor of the resolution exceed the vote cast against, then the appointment shall be deemed to be have been made. तो listed company ने थोड़ा सा ease out कर दिया because special resolution में ज़्यादा majority की जरूरत होती है, right? Of course, we always consider that in case of special resolution, we need 3 times in favor. Votes in favor should be 3 times the votes against. So obviously they are way more. They say, okay, fine, even if they don't get special resolution, but in general, the votes in favor are more than votes against, then also the appointment will be deemed to happen. तो भी हम मानेंगे कि अपॉइंटमेंट जो हो गई, कोई बात नहीं अगर स्पेशल रेजोल्यूशन से ना होके एक तरीके से ऑर्डिनरी रेजोल्यूशन से हो जाए. Further, an independent director appointed under the first proviso shall be removed only if the votes cast in favor proposing the removal exceed the votes cast against, and votes cast by public shareholders in favor exceed the votes cast against. मेन बात यह है कि अगर पब्लिक शेयर होल्डर्स को अपॉइंट किसी को करना है तो फिर यहाँ पे स्पेशल रेजोल्यूशन वाली बात ना लगाई जाए. अगर एक्सीड भी कर रहा है तो भी ठीक है. वही चीज रिमूवल के लिए दे आर सेइंग दैट इवन इफ दे आर in favor, the votes in favor, especially by public shareholders, it's more than vote against, then it is okay and good to go. And this amendment rationalized the process of appointment of independent director even if the special resolution per se fails. क्योंकि उससे क्या होता है, it could create further problems, right? कि अगर special resolution पास नहीं हुए तो हम उसे अपॉइंट ही नहीं कर सकते. तो सेबी ने बोला बिकॉज लिस्टेड कंपनीज में पब्लिक शेयर होल्डर्स को सुनना चाहिए. अगर वो किसी को अपॉइंट करना चाहते हैं या वो किसी को रिमूव करना चाहते हैं तो इतनी पावर तो उनको देनी ही चाहिए, राइट? एंड विद दिस वी एंड द amendments of chapter 16. few of the amendments अगर आपने latest topics पढ़े हैं तो वहां पे होंगी and few of the amendments जो हैं वो नहीं होंगी. Moving to lesson number 19 which talks about general meeting. It has more than amendments, only illustration form of like question form of things which is like for practice purpose. Like starting with the first, Mr. X, Miss Y, who is wife of Mr. X, Mr. C, son of X and Y, and that are the directors of XYZ Limited. They're also the members of XYZ Limited along with 4 other persons who are brothers and sisters of Mr. X. XYZ Limited to propose to hold the general meeting at the residence of Mr. X. So what happens? Have you read about when we were discussing about the general meeting notices? There they say that in the notice they need to give the roadmap plus a prominent landmark. If you have carefully read the topic of this notice in general meeting, तो उसमें ये लिखा होता है कि जब आपने नोटिस देना है ना जनरल मीटिंग का तो उसके साथ आपको एक रूट मैप प्लस एक प्रोमिनेंट लैंडमार्क देना है. लेकिन इसके 2 एक्सेप्शंस थे. तो फर्स्ट एक्सेप्शन वाज व्हेन मेंबर्स आर द डायरेक्टर्स एंड रिलेटिव्स ऑफ द डायरेक्टर्स. जब डायरेक्टर्स ही मेंबर्स हैं या उनके रिश्तेदार ही मेंबर है, देन देयर इज नो नीड टू गिव द रूट मैप एंड prominent landmark because generally they can talk to each other, they can ask each other and they can easily locate the area. So the route map and prominent landmark is not required to be provided. तो ये एक exception है ऑफ द कंडीशन कि जब भी आपने जनरल मीटिंग का नोटिस देना है तो उसके साथ आपको रूट मैप एंड प्रोमिनेंट लैंडमार्क भी देना है. सेकंड इलस्ट्रेशन इज XYZ Limited proposes to enter into a contract with PQR Limited. Mr. X and Y, who are promoters of XYZ Limited, hold 1.5% plus 0.5%, means in totality 2% of the total paid up share capital of PQR. यानी कि अलग अलग 1.5 and 0.5 है, मिलके 2% हो गया respectively. In this case, the shareholding of both should be disclosed in the explanatory statement of the notice since the extent collectively is not less than 2%. तो ये इंटरेस्टेड बन गए, ठीक है, क्योंकि 2% होल्ड करते हैं तो इनका जो इंटरेस्ट है वो डिस्क्लोज करना जरूरी है एक्सप्लेनेटरी स्टेटमेंट में. यस, बिल्कुल जरूरी है. The next illustration is, say a company XYZ Limited wish to hold its general meeting at a shorter notice. बिल्कुल hold कर सकती है 95% of consent के साथ. Immediately after the board meeting on the same day and the required consent of 95% of the members entitled to vote at the meeting is received before the time fixed for the commencement of the meeting. तो उन्हें जो consent चाहिए था वो भी मिल गया. Although in such a case the consent of 95% members entitled to vote is received, still the proxy requirements need to be complied by the company. So in general, this is a very important illustration, not given anywhere in the book, but here they have mentioned it quite different from the earlier ones. Like earlier two were easy. This is quite technical. They say, in other words, the board meeting and general meeting can't be held on the same day. वो कहते हैं ठीक है, जो 95% की requirement है, आपने बोला shorter notice की हमने रिक्वायरमेंट पूरी कर ली. जो आपने बोला 95% ऑफ मेंबर्स एंटाइटल्ड टू वोट, आपने कहा था हमने वो अरेंज कर लिया, फाइन, वेल एंड गुड, बट व्हाट अबाउट द प्रॉक्सी रिक्वायरमेंट्स? प्रॉक्सी रिक्वायरमेंट के लिए आपको एटलीस्ट 48 आवर्स बिफोर का टाइम चाहिए, जब आपको प्रॉक्सी फॉर्म डिपॉजिट होता है, जो पर्सन आ नहीं सकता वो अपना प्रॉक्सी देता है, व्हाट अबाउट दैट? तो वो जो कंडीशन है वो भी फुलफिल करनी जरूरी है, इसीलिए इन नटशेल बोर्ड मीटिंग एंड जनरल मीटिंग कांट बी हेल्ड ऑन द सेम डे. Moving to next illustration, considering the above illustrations, if the consent of all the members, that means 100% members entitled to vote at such meeting is received before the time for commencement of the meeting, the proxy रिक्वायरमेंट्स नीड नॉट बी कंप्लाइड विद. अब क्या होता है, अगर 100% जो ऊपर हमने जो बोला 95% की कॉन्सेंट आ गई, यही अगर 100% कॉन्सेंट आ जाए तो फिर प्रॉक्सी की जरूरत नहीं है, बिकॉज अगर 100% मेंबर्स मान रहे हैं कि हाँ भाई ठीक है, हम सबको कोई प्रॉब्लम नहीं है, तो उस केस में कोई दिक्कत नहीं है. इन अदर वर्ड्स, इन सच अ केस बोर्ड मीटिंग एंड जनरल मीटिंग कैन बी हेल्ड ऑन द सेम डे. बेसिकली जनरली दे आर सेइंग दे कांट बी हेल्ड, बट if they receive 100% consent of the members, then it can be held. Yes, it can be held. Next illustration is, consider a company where the number of members were originally large, say 500. Quorum fixed by the articles was 100 members. Subsequently, 450 members sold their shares, which were acquired by the remaining 50 members. यानी कि 500 members थे, उन्होंने बोला कि 100 members quorum में होने चाहिए, 450 members ने अपने shares बेच दिए और वो बचे हुए 50 ने खरीद लिए. Here the proceedings will be valid if all the members are present in person. So in the above case, if they are less than 50 members, there shall be no quorum. तो यहाँ पे 50 के 50 members का present होना quorum के लिए important है, because वैसे ही articles ने 100 members fix करके रखे थे, ठीक है, और 450 ने भले बेच दे, तो जितने 50 members बचे उन सबको in person आना जरूरी है quorum complete करने के लिए, क्योंकि वैसे भी proxies जो है वो quorum में count होते नहीं है. तो इस केस में जो है in person उनका आना is very very important. So when the members are 500, 100 is the quorum which is decided by the articles. In case 450 sell their shares to remaining 50, all 50 need to be present in person for complying for the quorum. The next illustration is, assume that the general meeting of a company is scheduled on 22nd September 2020 and the company has received 4 proxies for the same holdings of a member. That means one person has submitted 4 proxies with 5th, 12th, 10th and 20th. This we have read that when there are multiple proxies, the last or the latest one is valid, so we would consider the validity of 20th September only. The proxy that was submitted on 20th is valid, though on the same hand they say if proxies are not dated or bear the same date without the mention of time, all the proxies are invalid. तो वैसे भी अगर जब आप proxy का topic पढ़ोगे, you will see undated, unstamped and unsigned proxies, they are all invalid. इन सबको हम invalid category में ही मानते हैं, तो उस केस में ये invalid हो जाएंगे. वैसे multiple के केस में जो last और latest होते हैं, they are considered as proxy. So ये important topic है from the point of view of additional questions. तो ये एक तरीके से वो illustrations है जो case study form में आपको exams में आ सकती हैं. Moving to the last chapter of part B, chapter 20 on virtual meetings. So what was the amendment over here? वैसे ही अमेंडमेंट जो है ये आपने अपनी बुक में भी आपके गिवन है, जो लेटेस्ट बुक है उसमें गिवन है. आई विल टेल यू. सो देयर वर 5 मैटर्स अर्लियर व्हिच वर नॉट टू बी डेल्ट थ्रू वीडियो कॉन्फ्रेंसिंग और ऑडियो विजुअल मीन्स. तो पहले क्या होता है, 5 ऐसे मैटर्स थे जिसमें आता है अप्रूवल ऑफ एनुअल फाइनेंशियल स्टेटमेंट्स, बोर्ड्स रिपोर्ट, अप्रूवल ऑफ प्रोस्पेक्टस, ऑडिट कमेटी मीटिंग्स फॉर कंसिडरेशन ऑफ फाइनेंशियल स्टेटमेंट एंड अप्रूवल ऑफ मैटर्स रिलेटेड टू अमेलगमेशन, मर्जर, डीमर्जर. तो इस पे अमेंडमेंट आई थी ऑन 15th of June 2021 which allowed all the matters, all the transactions to be transacted through video conferencing और audio visual means. तो अब ऐसी कोई भी रिस्ट्रिक्शन नहीं है, कोई भी मैटर यानी कि सारे मैटर्स जो हैं वो डील किए जा सकते हैं, बिकॉज स्पेशली आफ्टर कोविड द रिस्ट्रिक्शंस वर देयर, राइट. तो ऐसे मैटर्स जो अगर आप बोलोगे करना ही नहीं है, तो ऐसे मैटर्स टेकअप करना बहुत डिफिकल्ट हो जाएगा. दैट इज वाई ये जो 5 आइटम्स की रिस्ट्रिक्शन है ये भी अब हटा दी गई है, और अब आप किसी भी मैटर को थ्रू वीडियो कॉन्फ्रेंसिंग और थ्रू अदर एवीएम मोड्स डील डील कर सकते हो. एंड द केस लॉ दैट डील्स विद अचिंत्य कुमार बरूहा अलाइज मंजू बरूहा वर्सेस रंजीत बारकर company appeal. So the NCLAT says that participation in board meeting through video conferencing, whether a right of a director, is subject to availability of facility by company. So this is also given in the book. The NCLAT observed that 173(2) it gives right to a director to participate in the meeting थ्रू वीडियो कॉन्फ्रेंसिंग मोड और एवीएम मोड, ये बताया गया है. एंड द सेंट्रल गवर्नमेंट हैज नोटिफाइड द रूल्स टू एनफोर्स दिस राइट एंड इट वुड बी इन द इंटरेस्ट ऑफ द कंपनीज. तो काफी फायदा रहता है कंपनीज को भी वीडियो कॉन्फ्रेंसिंग मोड से जो डायरेक्टर्स है वो ज्वाइन कर सकते हैं. इट इज क्लियर दैट द रूल्स रिक्वायर द कंपनी शैल कंप्लाई विद द प्रोसीजर फॉर कन्वीनिंग कंडक्टिंग. देखो बहुत सारा प्रोसीजर होता है. फॉर एग्जाम्पल फॉर वीडियो कॉन्फ्रेंसिंग यू नीड टू रिकॉर्ड द वीडियो कॉन्फ्रेंसिंग, यू नीड टू मेक श्योर नो बडी एल्स इज देयर विद द डायरेक्टर, यू नीड टू take his attendance. So ये सारी चीजें करनी पड़ती हैं. Secondly, the chairperson and company secretary has to take due and reasonable care. Like I told you, there are certain terms and condition where they say you need to take the declaration from that person that nobody else is sitting with him in that room while he is participating in the meeting, because board meetings are very very confidential. So all these things, and other than that taking his attendance, authenticating the same, तो उन्हें काफी reasonable due care लेनी पड़ती है. The appellant contended that sub rule 2E puts the burden on the chairperson to ensure that no person other than the concerned director is attending, and this would not be possible for a chairperson to ensure in a video conferencing. So the appellant said actually it is very difficult, and practically also it is very difficult to ensure that nobody else is sitting, right? We take the declaration but still. So NCLAT observed that they do not find force in the submission as rules read as a whole are a complete scheme. They're a complete scheme. See, they are something that you need to do, and sub rule 4D of rule 3 puts the responsibility on the director participating also. Both are responsible. Not just, you cannot say, you cannot blame the chairperson, because under the rules they say take the declaration, we will take the declaration. The director participating is also responsible. Not just the chairperson is responsible ideally, right? The chairperson will ensure that subclause E or clause 2 and the director will need to satisfy. So both are responsible. He will ensure from his part and director will also ensure the same. Appellants tried to rely on secretarial standards on meetings to submit the guidelines that participation can be done if company provides such facility. So NCLAT observed that such guidelines cannot override the provision under the rules. The mandate of section 173(2) read with rules mentioned above cannot be avoided by the company. So what the company says, company कहती है कि सारा responsibility chairperson पे आ जाता है, तो इसीलिए अगर company allow करेगी तो video conferencing करेंगे, otherwise हम तो नहीं करते. So they say no. NCLT said that you really cannot override. If the Companies Act is providing you a benefit, it has a motive behind it. So you should exercise it wherever required. You should exercise it. So hence NCLT came to the conclusion that the provisions of 173(2) are mandatory and companies are not to be permitted to make any deviations, and directed non-applicants before it to provide the facilities of 173 subject to the fulfillment of requirements. मतलब कंपनीज ये नहीं कह सकती कि हम तो बिल्कुल नहीं करेंगे, राइट? तो दे आर मैंडेटरी. अगर उन्होंने बोला है कि आपको प्रोवाइड करना है तो आपको प्रोवाइड करना चाहिए, राइट? एंड विद दिस वी एंड द अमेंडमेंट्स रिलेटेड टू पार्ट बी. पार्ट बी जो है वो सबसे इंपॉर्टेंट पोर्शन है इफ वी टॉक अबाउट द कंपनीज एक्ट. सो पार्ट बी जहां आप अच्छे से प्रिपेयर करोगे, उसी के साथ साथ आप अमेंडमेंट्स भी जरूर कर लेना. सो आई होप कि आपको ये वीडियो यूजफुल लगा हो. आई विल डेफिनेटली अपलोड द अमेंडमेंट्स ऑफ द रिमेनिंग chapters of part A and the miscellaneous ones. So make sure that you're subscribed to the channel and do these amendments if you want to score exemption in company law paper. I'll see you super soon in my next video. Till then, stay happy, stay blessed, and keep the preparations on. Bye bye.